Welcome back. Ever wondered how the patent office decides if your brilliant idea is actually new, especially for those inventions kicking around before, say, 2013?
Yeah, the rule book was definitely a bit different back then.
Exactly. And that's what we're diving into today, the Manual of Patent Examining Procedure, the MPEP, specifically Chapter 2100 on patentability. We're zeroing in on Section 2139.
Right, which covers rejections under the old first-to-invent system, that's pre-AIA 35 U.S.C. 102.
Now, you might be thinking, why dig up old rules? But honestly, if you're working with applications filed before March 16th, 2013, or maybe one's claiming priority back to that time, understanding this section is, well, absolutely crucial for getting past potential novelty rejection.
It really is.
Well,
Even though the U.S. moved to a first inventor-to-file system, these older pre-AIA rules are still very much in play for, quite a few applications, still winding their way through the system, and even some granted patents.
So a mistake there could still cause problems today.
Definitely. So our mission today, as part of this MPEP series, is to demystify these pre-AIA 102 rejections. We'll focus on Section 2139, aiming for a clear, practical takeaway on when these rules apply and how those different subsections work.
Without getting totally bogged down in legalese.
Hopefully.
Okay, so let's start right at the beginning. When exactly do these pre-AIA 102 rules apply?
Well, it all comes down to the invention's effective filing date. If an application was filed before March 16, 2013, it generally falls under the pre-AIA rules.
And that includes applications claiming priority to an earlier one filed before that date.
Yes, exactly. If you claim priority under, say, 35 U.S.C. 120 or 365C to a parent application filed before that cutoff, the pre-AIA rules usually apply. That earlier date anchors you to the old system.
Okay. But this effective filing date, it isn't always just the date you first filed that specific application, is it? Especially if you have related cases.
That's a great point. No, it can be more complex. The effective filing date often traces back to an earlier parent application. Could be a continuation, a divisional, even the national stage of a PCT application, provided, the requirements of the statutes like 120, 121, or 365CC are met.
What about CIPs? Continuation in part applications.
CIPs. That's a key scenario. Let's say you file a CIP and add significant new subject matter that wasn't in the parent application.
Okay.
Any claims in that CIP that rely only on that new matter, they get the filing date of the CIP itself, the later date.
Not the earlier parent date.
Correct. It's only the claims supported by the original parent disclosure that get the benefit of the earlier date. So for the new stuff, the CIP filing date is what matters for prior art purposes.
Right, that makes sense. Like drawing a line, old stuff gets the old date, new stuff gets the new date.
Precisely. That effective filing date is the benchmark against which potential prior art is measured.
Okay, so we know when pre-AIA 102 applies. Now let's unpack the how. What are the specific ways an invention could be rejected for lack of novelty under these old rules?
So the MPP Section 2139 guides examiners on using subsections A, B, or E of pre-AIA 102. Let's start with subsection B. It's often called the statutory bar.
Statutory bar sounds serious.
It is. Basically, subsection B says you're barred from getting a patent if the invention was publicly disclosed in certain ways more than 1 year before your effective filing date.
More than a year. And what counts as a public disclosure or a reference here?
The MPP lists several things, describing it in a printed publication anywhere, getting a patent on it anywhere, having it in public use here in the U.S., or offering it for sale in the U.S.
So publication, patent, public use, on sale, any of those more than a year before your effective filing date.
Can potentially block your patent under 102B. It's a strict cutoff.
But inventors sometimes talk about their work, right? There's that 1-year grace period.
Yes, exactly. The law allows inventors a 1-year grace period after their own disclosure to file. So if you publish an article, you generally have 1 year from that publication date to file your U.S. application.
Okay.
And an interesting detail highlighted in the case ex parte ola mentioned in the MPP is how that year is calculated. If the 1-year deadline falls on a Saturday, Sunday, or federal holiday,
you get an extension.
it rolls over to the next business day. A small, but sometimes very important practical point.
Good to know. Okay, so that's 102B disclosures more than a year before filing. What about patents or applications filed by other people before you?
Right. That brings us to pre-AIA 35 U.S.C. 102E. This is a bit different. It deals with certain U.S. patents and published U.S. patent applications acting as prior art.
Okay.
And the key thing here is that their effective prior art date is generally their U.S. filing date.
Wait, their filing date, not the date they were published or granted.
Yeah, correct. Under pre-AIA 102E, a U.S. patent or published application can anticipate your invention based on its filing date, even if it wasn't publicly available until much later, potentially even after your filing date.
Wow, okay. That's tricky. So a secret prior art, in a sense?
You can think of it that way.
Yeah.
It reflects the first to invent principle the system cared about, who filed first, even if the public didn't know about it yet. And it gets even more complex with international applications, PCT applications.
How do they fit into 102E?
Well, certain PCT applications specifically, those that designated the U.S. and were published in English, can also be used as 102E prior art. But there's a date condition.
Which is?
They must have been published on or after November 29th, 2000. For those specific PCT applications, their international filing date can be treated as their effective U.S. filing date for 102E purposes.
November 29th, 2000. That's very precise. Any particular reason for that date?
It relates to changes in U.S. law implementing treaty obligations, specifically the American Inventors Protection Act. The takeaway is that certain PCT applications published in English after that date get their international filing date as their prior art date under 102E.
Can you give us an example?
Sure. Let's say a German company files a PCT application on December 1st, 2000. It designates the U.S. and is later published in English by WIPO.
Okay.
Under pre-AIA 102E, the prior art date of that disclosure could be December 1st, 2000, its international filing date. So if you file a U.S. application for a similar invention after December 1st, 2000, that earlier PCT filing could potentially be used against you.
Assuming other conditions are met, you said. What else is needed for 102E?
A very important condition is that the inventive entities must be different. The inventors listed on your application must differ from the inventors listed on the 102E reference patent or application.
Do they have to be completely different teams of inventors?
No, interestingly, even if there's some overlap, like they share some joint inventors, just having one different inventor is enough. If your application lists inventors, A and B, and the reference lists A and C, that difference is sufficient for the reference to potentially qualify under 102E.
Okay, so even a single different inventor opens the door for 102E.
Correct. And just as a minor note, the MPP points out that subsection E itself is split into E1 for published applications and E2 for granted patents, just reflecting the different document types.
Got it. So we have 102B for things public more than a year before filing, and 102E for earlier U.S. or certain PCT filings based on their filing dates. What else?
There's also pre-AIA 35 U.S.C. 102A. This one looks back even further, potentially. It applies if the invention was known or used by others in the U.S. or described in a printed publication anywhere before the applicant's actual date of invention.
Okay, so 102A uses the invention date as the critical comparison point, not the filing date like B and A.
Exactly. That's the key difference. Subsection A asks, was this invention already out there, known, used, or published before the person applying for the patent even invented it?
When would this be particularly relevant compared to 102B?
It's often critical when you're analyzing disclosures that happened less than 1 year before the filing date. Those disclosures might escape the 102B statutory bar.
Right, because they fall within that grace period relative to the filing date.
Precisely. But if such a disclosure occurred before the applicant's date of invention, it could still be used as prior art under 102A. This is where, under the old system, inventors sometimes had to submit evidence to prove when they actually made their invention to overcome a 102A rejection.
Fascinating. It really highlights the differences from the current first-to-file system. So how do examiners actually put all this into practice when they write up a rejection?
Well, that's another key part of MPEP Section 2139. It doesn't just explain the law. It gives examiners practical tools. It includes specific, standardized language called form paragraphs.
Form paragraphs, like templates.
Essentially, yes. When an examiner rejects claims under pre-AIA 102, they often use these pre-approved form paragraphs provided in the MPP. This ensures consistency and clearly states the legal basis for the rejection.
So Section 2139 provides these templates for rejections under 102A, B, E,
and even other pre-AIA subsections like C, D, F, and G, which cover things like abandonment of the invention, prior foreign patenting, Or if the applicant didn't invent it themselves but derived it from someone else. Each scenario has corresponding form language.
So understanding those form paragraphs can really help you decipher an office action.
Absolutely. It tells you the exact subsection the examiner is relying on and the specific facts they believe support that rejection.
Okay, let's bring this back to the listener. For anyone still navigating patents under this older system, why is really grasping Section 2139 and these pre-AIA 102 nuances still so vital?
Because these are the rules that govern those applications and patents, period. If your application has an effective filing date before March 16, 2013, or it claims priority to one that does, this is the novelty law that applies. You can't use the current AIA rules. Understanding pre-AIA 102 isn't optional. It's fundamental to prosecution and validity for those cases.
And knowing the details, the effective filing date nuances, the different triggers for A, B, that's where the strategy comes in, right?
Definitely. It allows you to anticipate problems. If you know a certain publication exists, understanding whether it falls under 102A or maybe isn't prior art at all because of dates helps you draft claims smartly, argue effectively against rejections, and just generally build a much stronger case. It's about proactive strategy, not just reacting to the examiner.
So quick recap of the main points. Pre-AIA 102 applies if your effective filing date is before March 16, 2013.
Right.
102B is that one-year statutory bar based on public disclosures before the effective filing date. 102E uses the filing date of certain earlier U.S. patents, published applications, and some PCT applications as prior art, provided the inventors are different.
Correct.
And 102A looks at whether the invention was known, used, or published before the applicant's date of invention.
Perfect. And remember the importance of the effective filing date calculation, especially with CIPs.
And examiners use specific form paragraphs from MPEP 2139 when making these rejections.
You've got it.
All right, so here's a final thought to ponder. Thinking about this pre-AIA, first to invent, May's proving invention dates, navigating these different prior art dates under 102A, B, A, how did that shape patent strategy compared to the simpler first inventor to file world we have now? Are there maybe some, I don't know, lingering strategic echoes or lessons from that older system that could still be relevant even today? Something to chew on.
Definitely something to think about. And on that note, many thanks are due to Mike Shepard, our creative director. His vision and hard work really made this MPEP audio series possible.
Absolutely. And now for the necessary disclaimer. Please remember, this audio summary was put together using AI tools like ChatGPT and NotebookLM. It might contain errors or leave things out. It's meant for general educational and informational purposes only. This is not legal advice, and it's not a substitute for proper instruction.
That's right. For any authoritative guidance, you really need to consult the official MPEP itself, talk to a qualified instructor, or seek advice from a registered patent practitioner.